Good afternoon, everyone. We're just giving folks a minute to come into the room. So hello and welcome. My name is Shakima Appleton, and I am the Vice President of Webinar Programming for Philly Sherm. We want to thank you for joining today's session, 2026 Workplace Forecast, Key Legal Shifts and HR Priorities for the Year Ahead. During today's presentation, if you have any questions, please feel free to send them via the chat function on your screen, and we will read those aloud at the end of the webcast. We encourage you to choose speaker view for the presentation to allow you to best focus on our speaker. As a reminder, everyone is currently muted to ensure the best event experience with no distractions. We also ask that everyone make sure that their Zoom display name shows their full name. By labeling your display name to be your full name, we will be able to ensure that you receive our post-event survey so that you can receive your HRCI and SHRM credits for attending today's event. To rename your display name on Zoom, please go to the list of participants at the top of your Zoom window, then hover over your name and click on the rename button. Type in your full name and click OK. If you're having any difficulty, please direct the Philly Sherm participant in the Zoom meeting. If you have not done so already, please follow us on Twitter, Instagram, LinkedIn, and Facebook for the latest updates about these workshop sessions, as well as everything happening with Philly Sherm. And don't forget to check out our upcoming events, including our 2026 Philly Sherm Symposium, featuring keynote speaker Gregory Offner and closing session speaker Michael S. Cohen. Early bird pricing is still available. To take advantage of early bird pricing and to register for other Philly Sherm events, visit www.phillysherm.org. If you're not already a member of Philly Sherm, remember that members receive reduced or free event registration fees, big discounts on Philly Sherm Symposium, personal connections to the local HR and business community, our member-only resource area, including the membership directory, access to top leaders in our region, a chance to make a difference in our community, and the extensive resources of SHRM National. We want to remind you that you are eligible to receive one HR Business HRCI credit and one SHRM Professional Development credit for attending today's webcast. You will receive a follow-up email after the webcast with a survey link. The survey must be completed for you to receive the certificate for your credits. Once the survey has been completed, the survey forms will be emailed to you within 1 week. Today's webinar will feature Leanne Lane Coyle, attorney with Fisher Phillips. So Leanne, welcome back. Thank you for joining us today.
Thanks so much, Shakima. I always love being with the Philly Sherm community. Good afternoon, everyone. Let me go ahead and get my screen up and have our presentation underway. So today, I am going to give you a download of major things that should be on your radar to kick off the start of the year. And we're going to then talk about what we're forecasting in terms of some litigation or enforcement priority trends that we're seeing coming down the pike in 2026. So any questions, as Shakima mentioned, please feel free to drop them in the chat. I'm happy to save some time at the end to make sure that we address them. But my contact information is also available via this QR code if you have questions or want to connect on LinkedIn. I always love connecting with folks in our HR community here in Philadelphia. And as Shakima mentioned, I'm an attorney with Fisher Phillips. Fisher Phillips is a labor and employment law firm, so we exclusively represent management in workplace-related issues, whether that's litigation or advice and counseling. And I've been doing this now for over 10 years. I used to represent employees and then made the jump to management side. So I've seen both sides of the coin, and that helps me with my advice to management clients, particularly just understanding what motivates employees and frankly what makes them call an employment lawyer. So with that said, the general attorney disclaimer here that this doesn't constitute legal advice, but if you have specific questions or need advice, I'm always happy to connect and please feel free to reach out. So, topics that we're going to cover today, we're going to first discuss some key updates to Philadelphia's Ban the Box law. So, the fair chance hiring law that has been around since 2011, but recent amendments signed by Mayor Parker have shifted what that looks like and what that law protects. So, just some important things for you to do to update policies and make your training managers aware of under these new amendments. And then we're going to talk about updates to the Pennsylvania Human Relations Act through the adoption of the Crown Act that was just recently signed into law by Governor Shapiro, I think about maybe a week ago, 2 weeks ago. And then we're going to talk broadly about some changes that we expect to see from the EEOC. There is now a quorum because there is a new commissioner. So we're going to talk about how that's going to impact what enforcement from the agency looks like and how we're going to see a shift in, different enforcement priorities that might impact your policies in your workplace or create new risk factors. So let's dive in. So, as I mentioned, Philadelphia recently adopted an amendment to its fair chance hiring ordinance, and those are going to go into effect as of January 6th. So, for those who are unfamiliar, but hopefully most of the folks here are familiar with the Fair Criminal Record Screening Standards Ordinance. That has been law in Philadelphia since 2011. And basically, it limits the types of questions that Philadelphia-based employers can ask job applicants about their criminal history. And it really applies very broadly. So if you are an employer who hires someone within the city of Philadelphia, you do need to comply with the ordinance. So under October 8th amendments that Mayor Parker recently signed into law, a couple expanded protections under this ordinance. So going through them step by step. Number one, the amendments cover more workers. So whereas before the definition of employee was rather limited to what we traditionally think of in terms of a W-2 employee, the definitions have been expanded to apply broadly. So it covers independent contractors, not seen before under this ordinance. It also covers gig workers, so rideshare apps like Uber or things like DoorDash, Uber Eats. Really broad definition of workers to really cover anyone who performed services for remuneration. There are some small exceptions to that. So certain types of public employers are exempted. There's also a small exemption for domestic house workers. So, for example, if you hire a nanny in your home, there are exemptions to still enable you to ask about certain criminal history. But what you should know is that this really does apply broadly. And if you've been following this law since 2011, which hopefully you have, but you haven't applied those restrictions to independent contractors, you will need to under this expanded protection. So the definition of employment is also rather expanded. And what's key here is it really applies to all types of employment, but also vocational or educational training that doesn't have pay. So think apprenticeships or any type of vocational education where you have interns or the like. These restrictions on what you can ask about criminal history is going to apply broadly under in those contexts. And the expanded protections also clarify the reach of the ordinance. So we might typically think about this at just the hiring stage, a box on a job application, but really this applies through all aspects of the employment process. And that is defined in the ordinance as reemployment, continued employment, promotions, and termination decisions. So, really, what this law means is that all aspects of employment are covered under the ordinance, and employers have to be really careful to what degree they consider criminal histories when making any type of employment decision. So, what can you ask about and when can you ask about it? So, under the ordinance, employers can ask about criminal history. They can make what's defined as an inquiry only after a conditional offer. So, whether that's a conditional offer of employment, but even a conditional offer of promotion or rehire, it is at that point where a conditional offer is made that you can make an inquiry. So, what can you consider, and for what period of time can you consider it? So, felony convictions, this existed under the prior iteration of the ordinance. They can still be considered if they are within 7 years. And that is measured from, as you see here on the bottom, the date after release from incarceration. So the look back period begins as of the time that an individual is released from incarceration. But key here is that the ordinance changes how long you can look back for misdemeanors. So misdemeanors can now only be considered if within 4 years, and summary offenses may not be considered at all. Sealed or expunged records. This is an update under the new amended ordinance as well. Employers cannot consider sealed or expunged records. And what's really important here, and this creates an important notice requirement on employers, is if there is an expunged record or a sealed record that still hits as part of your standard background screening. So, for example, if you do the comprehensive FBI search, sometimes expunged or sealed records can still appear on those. If you do see those types of records on a criminal history report, the applicant or your employee must be given the opportunity to provide evidence that shows that the record was sealed or expunged. And upon receipt of such evidence, you may not consider those records when you're making any type of employment decision. So another key factor and something important to talk through about the changes under this new ordinance is the ordinance specifically requires that an individualized assessment be conducted when making any type of determination related to a criminal history. So what does that actually mean in practice? Well, you shouldn't and you may not have a blanket policy or exclusion regarding, not having certain types of criminal history. So caution against if, for example, your organization sees something in a criminal history report and says, we have a policy that we cannot have any employee who has this type of criminal history. That no longer is going to hold a candle. And you really do need to conduct an individualized assessment. And you really need to be careful about how you articulate how the assessment was conducted to the applicant or the employee to really make sure that you are not running afoul of the ordinance. So, what should you consider when you're conducting the individualized assessment? Well, really, it's a multi-factor test and not one factor should be dispositive, but you should consider the nature and gravity of the offense itself, how long it's been since the offense and evidence of rehabilitation. So if we're talking about someone who has a conviction from the 80s, who, significant time has passed, and you can see that that person has really rehabilitated since being released from incarceration and has really, held steady jobs, has really turned a new leaf, if you will, that should play a big role in the individualized assessment, and proper consideration should be paid. And that speaks to the next bullet point here: employment history and professional references, um, relevance of the offense to job duties. So if we're talking about, someone who is going to be working with vulnerable communities and there is allegations of abuse, or I'm sorry, not allegations, convictions related to abuse, perhaps maybe that's a situation where there is some nexus between the conviction and the type of job duty that this individual is being asked to perform. Under those circumstances, that individualized assessment might lean towards the criminal history being appropriately considered for the employment decision. But if it's something that is really completely unrelated, you should be really careful about how you proceed in basing any employment decision off of that type of conviction. And here's another important update too. So the ordinance clarifies how and when you may consider pending criminal charges. Again, you shouldn't have any type of blanket policy that would exclude an employee purely because they have a pending criminal charge. You should also conduct an individualized assessment. You can, under those circumstances, ask a current employee if you discover or want to learn about a pending criminal charge. If there is reasonably reliable information indicating that there is some nexus between the charge and the employee's duties. So let me give you an example here. If we have a bus driver is interesting because they're subject to DOT requirements. So that's another point to add too. You might want to also be mindful of other related regulations that need to be considered with an applicant or employee. But let's say we have an employee who is currently working for us where they really do need reliable transportation to and from the job because they need to travel as part of their job responsibilities. But you find out that they have a DUI pending charge that could impact their ability to drive. If there is some nexus between the charge and the employee's duties, that is when you can ask them about a pending charge. You should also be able to point to a written policy that clearly explains what type of offenses should be reported by current employees to management or HR. So, end of year is always a good time to do a review of your employee manual, handbook, or relevant policies. And if you don't have a policy that speaks to reportable offenses, and that might be something that, because of the nature of the work of your organization or because of the nature of certain job functions within your organization, could be impacted by certain types of charges, you should take some time to review whether you need to identify reportable offenses within your policies. And I should make clear that the statute specifically, or the ordinance specifically, says that you can only ask about criminal charges of a current employee where you can point to a written policy about reportable offenses. So anytime that you are going to make an employment decision that is based on criminal history, first, as with everything, but particularly because essentially criminal history is, for lack of a better way of putting it, being considered a protected category under this ordinance. Any adverse action, it must be justified, it must be job related, and it should be consistent with business necessity. Now, all the HR folks in this webinar know that, those similar principles that we would apply to when we're taking an adverse action, anytime that someone falls in a protected category or has engaged in protected activity, you want the same type of analysis, right? Is there a legitimate business reason behind this? But particularly here with criminal history, you should be able to tie it to a articulable business necessity and a reason that it's job related. So if you have someone who is going to be working in finance and they got into a bar fight in college and there's an assault conviction on their criminal history report, that seems to have less of a nexus between their job responsibilities in the financial world, getting into a bar fight, than let's say, for example, a conviction of perjury or a conviction of some type of fraud, that would have that articulable nexus to the type of job responsibility that that applicant or the employee is going to be performing. And, not to sort of make it about consulting outside counsel, but these are one of the areas where you might want to consider consulting either internally with counsel or with outside counsel before you make an adverse decision, just to make sure that you've really conducted the individualized assessment and you can tie it to a specific job related reason. And that's important because, and I'm going to, the next slide here. This is really important because under the expanded ordinance, there is a rebuttable presumption of retaliation if you take an adverse action within 90 days of conducting a criminal history report, or what the statute calls protected activity. So if you are basically making a decision, there is going to be a presumption that it was based on an impermissible reason under the ordinance. How can you overcome that rebuttable presumption? You will have ideally documentation and an articulable basis to show that there was good faith in the decision making and that it was tied to the reasons we just mentioned, a specific job related reason and for legitimate non-retaliatory reasons. So the ordinance also creates some enhanced exposure in terms of civil penalties. So there are higher civil penalties under the ordinance. There is also a new liquidated damages category. And the expanded ordinance also creates a more favorable path for job applicants and employees to bring a private right of action against a potential employer or a current employer. So there is still an administrative exhaustion requirement, meaning that a job applicant or employee has to file with the Philadelphia Commission on Human Rights, and they have to do that within 300 days. But under the expanded ordinance, the employee or applicant can bring a private cause of action after a year. They don't have to wait for the agency to issue any type of probable cause or no probable cause finding. So it does sort of lower the threshold and open the door for more litigation under this ordinance. So there are also some new notice requirements that should be on your radar, and you should take time updating job ads to make sure that anytime you state in a job ad that the organization will conduct a background check, you should add specific language that says, and this is taken from the ordinance itself, that any review will be based on an individualized assessment of the applicant's specific record and duties and requirements of the job. So update your job ads, make sure that they are, consistent and include this language. If you do have anything within those postings that mention that the position is subject to a background check. There are also certain notice requirements if you are going to take an adverse action based on a criminal history report. So, similar to, you're likely familiar with notice requirements under the Fair Credit Reporting Act. These are very similar to that. If you decide to not move forward with a conditional offer that you've made related to an applicant, or if you decide to terminate an employee based on some criminal history report, you must provide written notice before that final decision is made. And the notice has to include certain things in it to make sure that you comply with the ordinance. So you have to identify the specific convictions considered. And then you should also provide copies of what you reviewed and relied on in making the preliminary determination. The notice should also include a summary of rights that applicants and employees have under the ordinance and a statement that your organization will consider errors, omissions, rehabilitation efforts, or mitigation, or really broadly any evidence that the applicant or employee wants to submit with instructions on how to submit it. You have to give the applicant or the employee 10 business days to respond and provide that evidence before the final decision is made and the final action is taken. So it's important coming into the new year to just review process and make sure that your process provides for this notice requirement. So, compliance checklist for you heading into the new year. What should you do to get ready for the ordinance going into effect as of January 6th? We've already talked about you should review your internal forms and practices to make sure that they comply with the notice requirements, make sure that your job postings comply with the individualized assessment language. Really do an audit to make sure that everything is squared away and complies with the expansions under the new ordinance. If you don't have notice and documentation policies in place already, you should make sure that you get those squared away. One thing that I should mention is that the Philadelphia Commission on Human Rights is expected to create sample forms for organizations. They have not released them yet. Hopefully, they will do so soon in advance of the January 6th effective date. So, if you're looking for samples or if you're looking for direction on the type of forms that your organization should implement, check in with the commission, see if they've released them. If you want to create a more tailored and individualized approach, you can always consult with outside counsel. That's something that Fisher Phillips helps its clients with. So get all of your documentation and paperwork squared away. And it's really important to update training managers and talent acquisition teams about these changes. I think particularly because of the look back periods changes with respect to misdemeanors, we want to make sure that everything is clear with hiring managers and talent acquisition to not inadvertently create exposure with a violation under the ordinance. We anticipate that the commission is going to be pretty aggressive when it comes to investigation. And, we have sort of gotten the sense from the commission that they do plan on doing proactive investigation to check on compliance for organizations. So even before, the possibility of a complaint or a lawsuit is filed, you should make sure that you are keeping all of your documentation related to notice or the adverse action letters, all of those things properly documented so you can be prepared in the unfortunate situation that you are facing an audit from the commission. And that record keeping, by the way, really should include documentation that helps memorialize the individualized assessment that you conducted. So whether that looks like an internal memo or, memos to file from HR that really walks through and discusses why the specific offenses are job related, why consideration of, for example, the time that's passed or rehabilitation doesn't change the analysis. Really carefully documenting that individualized assessment will help both with investigations from the commission, and it will help when it comes to what we talked about in terms of that rebuttable presumption. And then, as always, any good employment attorney will tell you consistency is key, particularly, sometimes these principles related to conducting criminal history reports can also interweave other types of employment related claims. So there can be intersections between, for example, this ordinance and race discrimination claims, sex discrimination claims. So you want to ensure that you are approaching these situations with consistency to both comply with the ordinance and also avoid inadvertent, subtle forms of discrimination based on other protected characteristics. So that is the rundown of the expanded ban the box protections going into effect in Philadelphia as of January 6th. Next on the update radar is a statewide update related to the Pennsylvania Human Relations Act. So on, I think it was November 25th, Governor Shapiro signed the Crown Act into law. So let's talk about what the Crown Act is. So what the Crown Act does is it officially adds to the definition of traits historically associated with race that is currently under the definitions of race in the Pennsylvania Human Relations Act to add hair texture and protective hairstyles to that definition of traits historically associated with race. And these amendments explain and include examples of what we are talking about when we're talking about hair texture or protective hairstyles. That includes locks, braids, twists, coils, bantu knots. It includes afros, extensions. That's not an exhaustive list, but really any of those hairstyles or hair textures that are historically associated with a particular race will fall under the definition of hair texture and protective hairstyles. Also included are head coverings or hairstyles that might be tied to religious creed. So something to think about here is not just the hair on our head, but beards that are associated with religious belief. Any type of head coverings like a headscarf or any type of, facial or head covering that is tied to some type of sincerely held religious belief or religious creed. I should mention that the definition of religious creed itself has not been amended to include hairstyles or head coverings, but rather this falls under the subsections of the definition of race. It doesn't, I say that because, it's not going to change what our understanding of religious creed is, but it should flag for you that hairstyles and head coverings, not just in the traditional race-related sense, but also tied to religion, are going to be protected under the Pennsylvania Human Relations Act. Now, this shouldn't be a significant change for employers because the Pennsylvania Human Relations Commission actually 2 years ago issued guidance on, that concepts of race and religious creed should include hairstyle and head coverings. And the Pennsylvania Human Relations Commission has been enforcing hair-related discrimination or head covering-related discrimination since it passed that guidance 2 years ago. But under the Crown Act, those protections are memorialized in the law. And this passed with pretty unanimous support on the state level. Something that I think, is kind of unheard of right now with the division at our state government level. So this had broad support and was something that I think lawmakers felt was a long time coming and just really memorialized principles that already should have been in action. One key distinction that the Crown Act makes is it still provides an avenue for employers to maintain, adopt, or enforce workplace policies or rules that might impact hair texture, style, or coverings. But four factors must be met in order for an employer to adopt and enforce those types of rules. So, there must be a legitimate health or safety necessity tied to it. So when we're talking about, let me give you an example here. Let's say, a job site that requires a hard helmet be worn at all times for safety reasons. And there's an employee who, let's say, has a fabulous afro that is out to here and makes wearing a hard hat helmet impossible. If the employer can really show, look, this is related to a clear safety necessity, and we apply the requirement to wear a hard hat helmet uniformly, based on a legitimate need to protect the safety of our staff, an employer can enforce that rule with respect to that employee and say, look, you either have to wear your hair in a way that will still enable you to wear the hard hat helmet, or take disciplinary action if that employee refuses to comply. These concepts are what we just talked about. Legitimate, non-discriminatory basis needs to be specifically tailored to the job or activity and applied uniformly across all similarly situated employees. So if you have some employees where you don't enforce they wear the hard hat helmet while on the job site, you are going to create risk and exposure for a race or religious creed related discrimination claim under the PHRA. One thing that is important to keep in mind, though, when your organization is enforcing a rule or implementing a policy that can impact the way an employee wears their hair or, has some type of head covering, you should, even if you meet that four-factor test, you still want to be mindful of your obligation to engage in the interactive process to determine whether a religious accommodation needs to be granted. So just make sure that in complying with the Crown Act and or looking to that four-factor test to enforce a rule related to hair texture, style, or head coverings, that you are still appropriately considering whether a religious accommodation, an exception to a rule or regulation, needs to be granted based on a sincerely held religious belief. So, in terms of compliance checklist, what should be on your to-do list heading into the new year and getting situated, review and revise any policies related to appearance or grooming. I think particularly you're going to want to take a careful look at your uniform policy and look for words that I think might open up some additional scrutiny. For example, like neat or well-groomed or professional. Those terms by themselves are not problematic, but I think that you want to make sure that, you're not using terms that are too ambiguous that could potentially suggest some inferred or implicit bias against hair texture or styles traditionally associated with certain races. Part of the reason and momentum behind this law, and one of the lawmakers who supported this bill really discussed how, for example, African American women have historically faced significant discrimination in the workplace based on how they wear their hair. Unfair assumptions about professionalism based on the way that they wear their hair, or a need to maintain a consistent hairstyle, even to just have people remember exactly who they are. Those things they've always been problematic, but they should be on your radar to ensure that we are protecting people and that people aren't making unfair assumptions based solely on hair texture style. Um, Another key important aspect of this, I ask my clients to audit their job descriptions every year for a number of reasons, but the Crown Act is a good other reason to make sure that you are auditing your job descriptions, because if there is going to potentially be some need to enforce a rule that might impact the way an employee wears their hair or has a head covering, you should be able to point to your job description to show and articulate how that rule is specifically job related. And if you are going to enforce a rule or have some type of policy that impacts hair texture, style, or head coverings, make sure that you carefully document how you went about considering that four-factor test. Make sure that you have some basis that you can point to that demonstrates each of those four factors are met before you, specifically with an employee, enforce that rule or take any disciplinary action against that employee for not following some type of uniform rule or grooming rule. And I already mentioned you should still review for religious accommodation inquiries, follow the interactive process, and train managers on these updates. I think one of the big things too that managers should understand that I perceive to be a big risk point is even well-intentioned feedback to employees, even if within the same protected group. So tying back to the momentum behind this law, Black women feeling that they were unfairly scrutinized based on the way that they were showing up in the workplace and wearing their hairstyle. If you have a well-intentioned Black female manager who is talking to their subordinate and suggests to them that they should wear their hair in a certain way to appear more professional, while that might be well-intentioned, those type of suggestions they run afoul of the protections under the Crown Act. So we should make sure that managers understand the nuance and understand that they should really forego with these ideas that they have about appearance and professionalism when it comes to the manner in which someone wears their hair. It's going to be an important conversation for you to have with your managers and for them to understand what these restrictions under the Crown Act are. So, moving along to a more comprehensive federal look at some litigation trends and enforcement priorities that should be on your radar heading into 2026. All right, mindful of this time, I have quite a bit to get through here. So, the EEOC just confirmed a new commissioner. So, Brittany Panuccio was just sworn in as a commissioner to the EEOC on October 27th. Her term is going to run through July 2029. And who is Brittany Panuccio? Who is Commissioner Panuccio? Well, she was a former assistant U.S. attorney in the Southern District of Florida. She did have a brief stint in big law. She worked at Jones Day for a year, but she then immediately transitioned and went to federal agencies. She worked at the Department of Education for a number of years. So she has agency experience, and she has in the past she has vocally expressed skepticism towards DEI programs. So her view on DEI really closely aligns with another EEOC commissioner, now the chair of the EEOC, Andrea Lucas. So we expect that some of the enforcement initiatives articulated by the Trump administration are really going to take hold and be driven with Commissioner Panuccio's confirmation and joining of the EEOC. So why is her appointment important, and why does this impact what we're looking at in terms of workplace law forecasting? So The EEOC has only had two commissioners since January, after President Trump made a rather unprecedented move to oust two Democratic members whose terms were not expiring until July 2026, and I believe it was July 2028, respectively. That had never been done before. EEOC commissioners are, they serve a term and they carry over regardless of the administration. But President Trump did remove two Democratic members early in January. So the EEOC has only had two commissioners. Trump appointee Andrea Lucas, who is serving as the acting chair, is now formally the chair, and a Biden appointee has also been still serving as a commissioner. But what's problematic about having only two commissioners is the EEOC, in order to take any type of enforcement action, for example, rulemaking or issuing any type of workplace guidance, the EEOC requires a quorum. So there are 5 commissioner seats, and there needs to be at least 3 commissioners to have a quorum to be able to vote on proposed rulemaking, proposed guidance. So Commissioner Panuccio's confirmation restores the 3-member quorum, and it gives the Republicans a majority. So there are 2 Republican commissioners versus the 1 Democratic commissioner. So we expect when there is going to be any type of voting on things like rulemaking or proposed guidance, that the Republican majority initiative will be pushed because there are 2 Republican commissioners. So, what does this mean, and what do we predict in the coming 2026 year? Everyone here on this webinar understands and has been living in the fundamental shift that we've been experiencing in the employment law world since President Trump's, being sworn to office in January. Quickly, upon his confirmation, he issued a number of executive orders that really do transform the way that we view certain employment law protections. And the Trump administration has a very aggressive agenda when it comes to its enforcement priorities in the employment law space. So I'm sure that all of you already are acutely familiar with the scrutiny that DEI programs have faced under the Trump administration, and particularly the executive orders. Chair Andrea Lucas is really considers herself an ally to the Trump initiative when it comes to attacking DEI programs. So, for example, I think just about a week ago, she publicly embraced on LinkedIn a title that was given to her in a Wall Street Journal headline, calling her Trump's DEI slayer. She reposted that article and said, "That's right, buckle up for more." So she really is publicly embracing this administration's agenda towards scrutinizing and even potentially creating rules or guidance that attacks these programs or tries to outright ban them. So we are on the lookout at Fisher Phillips for technical guidance or maybe even a proposed rule that might regulate or restrict private sector employers' ability to have DEI programs, or what those DEI programs what they look like. Another key thing that we are looking at that we think is on the horizon is the Pregnant Workers Fairness Act passed by Congress a couple years ago. The EEOC issued a rule on the PWFA. At the time that the rule was passed, Chair Lucas was vocally in opposition to the rule, specifically because the rule included abortion-related accommodation provisions. So for those unfamiliar, The PWFA rule specifically included that employers should make accommodations for pregnancy related conditions that include abortion care, which could take the form of giving an employee time off to undergo an abortion procedure, things related to abortion care. The EEOC under Biden took a very expansive definition of pregnancy related conditions. Chair Lucas was vocally opposed to that. She issued a rather scathing letter regarding the PWFA regulations related to abortion related accommodations. And she continues to be vocal about that. A federal court actually very recently struck down that portion of the EEOC's rule related to providing accommodations for abortion related care. So the entire PWFA rule really is on shaky ground right now. And with Commissioner Panuccio's confirmation, we understand that she has also expressed skepticism towards the legality of that type of provision. So we think that it's likely that the EEOC might rescind the abortion related accommodation requirement from the rule or potentially withdraw the rule entirely, taking the commission back to square one to issue a rule regarding how employers comply with the PWFA, which ultimately could create a bit of ambiguity and gray area for employers. Now, ultimately, employers sometimes think that regulations are the bane of its existence, but they also provide clarity on how you comply with the law. So it could create some ambiguity that makes it harder to deal with these issues in real time. Another thing that we expect from the new makeup of the EEOC and the reestablished quorum is really an emphasis on enforcement related to religious discrimination. So the current EEOC leadership, Chair Lucas and the new commissioner, have both emphasized a desire and enforcement priority towards protecting workers from religious bias and harassment. I should note specifically that the emphasis is on alleged anti-Christian bias. Chair Lucas has also been very vocal about anti-Semitism issues, so it's not related. It's not limited solely to anti-Christian bias, but it's important to be aware of there is really an emphasis when we're talking about religious discrimination on these concepts of anti-Christian bias in the workplace. And I think that this enforcement shift under Trump's EEOC is going to create some gray area for dealing with intersections between protections for LGBTQ plus workers and protecting religious freedoms and sincerely held religious beliefs. So, for example, the EEOC had a workplace harassment guidance that it issued under the Biden administration. Under Trump's sweep of executive orders in January, he quickly rescinded that guidance. What that guidance did is it specifically clarified that an employer is not required to provide a religious accommodation to an employee where that might create harassment or discrimination against an LGBTQ plus worker. So quick example of that is when we're talking about pronouns or misgendering. You have a transgender employee who uses she, them pronouns, and you have another employee who says that their sincerely held religious belief mandates that they use a he, him pronoun because that employee, the trans employee, was born biologically male. Under that EEOC harassment guidance, there was clarity that an employer didn't have to accommodate that religious employee's sincerely held religious belief. With the guidance scrapped and with the enforcement priorities of this commission, that is no longer clear. And it remains to be seen how these issues are going to be played out. So we need to see how the EEOC deals with it in enforcement, and we might need to see how it shakes out in legal claims in court. And I mentioned this already, there really will be a restriction from the EEOC on gender identity enforcement. This has already resulted in litigation. The EEOC has already made vocal that they do not intend to enforce with the same vigor under the prior administration discrimination claims related to gender identity. Trump's January 2025 executive order expressly stated that sex does not include within it the concept of gender identity. That might run contrary to Supreme Court precedent. SCOTUS's decision in Bostock, I think that that's at odds with it, but it really hasn't been fleshed out fully within the courts, and it hasn't gone back up to the Supreme Court. So there is a lot of ambiguity right now in the law. A federal court recently struck down EEOC guidance that had specifically addressed bathroom access and pronoun accommodations. But that might be at odds with the Supreme Court's decision, and I think it's likely to end back up at the Supreme Court. And employers are kind of between a rock and a hard place because we think that there is going to be less enforcement from the agency related to these concepts, but Bostock is still good law, and transgender and gender nonconforming employees are protected under Title VII. So they still may bring discrimination claims within an appropriate federal court. So we'll see how this plays out. Bathroom access is a hot button issue for this EEOC. Chair Lucas has already been very vocal that she believes female workers should have unequivocal right to be able to use a single-sex bathroom based on biological sex. We think that the EEOC might issue rules or guidance related to bathroom access, even potentially requiring that employers provide employees with bathroom access based solely on sex assigned at birth. I think that's going to result from challenges from the states. Don't forget that you might operate in a state that has certain protections that expressly protect gender identity. Pennsylvania is actually not one of them. There is a bill currently on the floor to amend the PHRA to specifically include in the definition of sex gender identity, but other states have amended their laws to expressly include gender identity as a protected group. And we've already seen the EEOC is prioritizing what they call anti-American national origin discrimination. We expect to see an increase in these types of claims, both at the agency and in litigation. And in part, the Supreme Court, their recent Ames decision, made clear that majority employee, someone who falls into a typically or historically considered majority group, like, for example, white employees, they do not have a higher burden to meet when it comes to establishing discrimination claims. These slides will be circulated. So if you haven't seen the new guidance, it's not formal guidance, but there is a leaflet, a one-pager that the EEOC issued regarding discrimination against American workers. So if you haven't looked at it, I encourage you to take a look and just apprise yourself of this, what's been issued by the EEOC, because we expect that they're going to really focus enforcement and investigation efforts on what they're calling anti-American bias. And the last note here is watch for EEOC General Counsel nomination. Trump just nominated this fellow. His name is M. Carter Crow. He's a global head of employment and labor at a management side firm. He's expected to bring a very employer-focused perspective. He hasn't been confirmed yet, but it's important to note that he has been very vocal and supportive of the EEOC efforts. in tackling what they call anti-American and anti-Christian bias. And he's also likely to reinforce what we view to be a shift in the agency moving away from enforcement via litigation and towards more of an administrative and advisory board type role that we've seen under the Trump administration. So we are right on the nose at 1 o'clock. I am happy to hang around to answer questions. I always run a little over, so I appreciate everyone's time today. If you have follow-ups, please reach out. LinkedIn me, email me, whatever. I'm happy to connect.
Thank you, Leanne. So you have two
So
questions
you have two
in the
questions.
chat.
Okay.
Okay.
Let me see. Let me pull these up. Hold on. Okay. So, is there a requirement that a background check post offer needs to be disclosed in a job posting? That's an actual excellent question, Rebecca. It might depend. You know what? Let me check just to be double sure. I understand under the new ordinance that you do have to articulate the language that we discussed. But whether it needs to be specifically in the job posting, I'm not sure sitting here. So if you want to shoot me an email, I'll be sure to follow up and give you a clear answer on that. How do we address complaints from employees who refuse to share the bathroom with individuals who are not of the same sex at birth? Um, you know, it, Susanna, this is a really hard and complicated issue. It's something that I am working through with my clients, and I hate to give you the it depends answer. Some of this might be dependent on the individual factors at play. But what I would say is that you need to take a strong stance and point to policy where needed. If you have an employee complaining about, someone else using the bathroom who are of not the same sex assigned at birth, I would politely tell them that that's under our policy, we allow employees to use a restroom that aligns with their preferred gender. And unless employee complaints are really tied to some sincerely held religious belief, I don't think that it triggers some of those issues that we expect to see coming through the EEOC. If there are specific employees who are vocal about it, and there's not the ability to provide them with like a, gender neutral single bathroom that they can use, you have to sternly but politely tell them tough luck. Because I think the risk of a harassment claim from another employee who is a member of the LGBTQ community, that risk is higher in that setting.
Thank you. I figured it's not going to be a simple answer, but
Yeah.
it was worth hearing that from you. Thank you.
Yeah, it's a tough one, but I think that there is a way that you can articulate it politely, but rather firmly. And I would point back to if you have things in your policy about what it means to be respectful towards other employees, maybe tying back to look at the end of the day, we must be respectful of our colleagues and coworkers. If you have specific concerns that you want to share that we might be able to address, opening it up to them. But I think you just have to be very curt if they do mention some type of religious related reason to the objection, a careful analysis should be paid. And you might want to consult with an attorney about that under those circumstances because of this shift in the EEOC. But otherwise, point to the policy and say, let's be grown-ups, let's be respectful, and leave it at that.
Awesome. Thank you so much. Thank you to each of you for joining us for today's webcast. Leanne, thank you for joining us again for all this important information that we need to know going into 2026. As a reminder, please look for the follow-up email with the link to the survey. Be sure to complete the survey in order to receive your HRCI and SHRM credits. On behalf of Philly SHRM, thanks again and enjoy your afternoon.
Thanks, everyone.